Good afternoon. My name is Muhammad Abduroaf. I'm a practicing advocate in the Western Cape, and today's short video will deal with the aspect of child maintenance. When it comes to child maintenance, the child's best interests are of paramount importance. This principle is immortalised in our Constitution and applied in our courts of law. Therefore, in relation to child maintenance matters, and specifically to child maintenance courts, the moment a parent files an application for child maintenance, the principle should apply. Before we move on a side note, it is not only child maintenance that a maintenance court deals with. A spouse may take the other spouse to the maintenance court for personal maintenance. Let's move on to parental maintenance obligations. Both parents have a duty of support towards their minor child's proper living and upbringing. This should be in accordance to the means, standard of living, station in life, and the needs of the child. This is found in our Constitution, common law, and also applies to divorced parents. According to Section 15.2 of the Maintenance Act, the duty extends to such support as a child reasonably requires for his or her proper living and upbringing, and includes the provision of food, clothing, accommodation, medical care, and education. Furthermore, the duty is not discharged when one parent earns substantially more than the other. According to Section 15.3 of the Maintenance Act, in determining the maintenance amount, the maintenance court must take into consideration the following: that the duty of supporting a child is an obligation which the parents have incurred jointly, that the parents' respective shares of such obligation are apportioned between them according to their respective means, and that the duty exists irrespective of whether a child is born in or out of wedlock, or is born of a first or subsequent marriage. Any amount so determined shall be such amount as a maintenance court may consider fair in all the circumstances of the case. Lastly, there is an onus on both the maintenance officer and the maintenance magistrate in placing evidence before the court in determining a fair maintenance amount. This is our starting point. Processing the maintenance application. When a parent approaches a maintenance court for child maintenance, it is the duty of the maintenance clerk to expeditiously process the application. In doing so, the clerk, through the other resources the maintenance court might have, should ascertain the details of the other parent and ensure that he or she is brought to the maintenance court as soon as possible for a maintenance inquiry before a maintenance officer. Therefore, for example, should the maintenance clerk not have the living or working address of the father or the mother, then he or she must enlist the assistance of the maintenance investigator to obtain it. For that, he or she can make use of search companies, tracking resources, the maintenance investigator, and furthermore banks, SARS, etc., in order to obtain the details of the other parent. Now, let's move on to the issue concerning getting the non-paying parent to the maintenance court. After the maintenance application has been processed, it is a duty of the maintenance court to ensure that the non-paying parent makes his or her way to the maintenance court as soon as possible for a maintenance inquiry. This inquiry is held before a maintenance officer. Even if the maintenance court's diary is quite full, it should still be expedited, giving both parents adequate time to make arrangements to appear at the maintenance court. Therefore, if the next available date for the maintenance inquiry is in 3 months' time, the parties can use this time to make arrangements with their work, obtain necessary information for the inquiry, or make alternative school traveling arrangements for the kids. There should therefore not be a delay in notifying the parents of the date of the maintenance inquiry. Furthermore, when notified of the court date, both parents receive a document stating what information they should bring to the maintenance inquiry. These include 3 months bank statements, salary advice, and proof of expenditure for the parents and the minor children. Giving the parties adequate time to obtain this information will be vital and in the child's best interest. The last thing we want is for the matter to be postponed to another date due to either parent not having been given adequate time to obtain such documentation, even though the mother made the application many months ago. Now let's move on to the maintenance inquiry before a maintenance officer. The maintenance inquiry is the next legal step in the process. This is where both parties appear in court. This is where things becomes a bit interesting. Sometimes at the inquiry, it is the first time the parents are in the same room together. Since the child was conceived, quite often both parents do not know how much the financial both parents do not know the current financial affairs of the other parent. The parent asked to pay the child support, furthermore, does not know how much a child costs to be maintained. Then we have the possibility of the issue of denial of paternity. What sometimes happens is that the father denies paternity. This he would either do out of spite or due to genuine doubt on his side. This would often be the case if there was a brief encounter between the parties when the child was conceived. Sometimes the father is married to someone else, and for the sake of his current marriage, he needs to deny paternity. Once the paternity tests are finalized, the parties would need to return to court again for the results. If the results are positive, in that he is the father, then the inquiry proceeds. If he is not the biological father, the application would obviously be removed from the role. Now we can move on to the role of the maintenance officer. Again, the golden standard in which the inquiry should be conducted is that of the child's best interest. This is of paramount importance. The maintenance officer should therefore ensure that all the financial information about the parties are properly disclosed. This is very important. However, at the same time, the maintenance officer should try to settle the matter, taking into consideration the child's best interests. Should the parents not be forthcoming regarding their income and expenditure and the needs of the child, then the maintenance officer must subpoena witnesses if need be and make use of the maintenance investigator, which is dealt with next. Section 7.1d of the Maintenance Act empowers the maintenance officer to require a maintenance investigator of the maintenance court concerned to perform such other functions as may be necessary or expedient to achieve the object of the Act. Section 7.2e of the Maintenance Act empowers the maintenance investigator, after being so instructed by the maintenance officer, to gather information concerning, number 1, the identification or whereabouts of any person who is legally liable to maintain the person mentioned in such complaint or is alleged so liable, the financial position of any person affected by such liability, or any other matter which may be relevant concerning the subject of the complaint, or gather such information as may be relevant concerning a request referred to in section 1c above. Now that we looked at the important role of the maintenance officer and maintenance investigator, we move on to the role of the maintenance magistrate. This is where the formal inquiry takes place. Should the parties not be able to come to an agreement regarding the amount of child maintenance to be paid at the inquiry before the maintenance officer, the matter would then have to be taken or forwarded to the maintenance magistrate for formal inquiry. Here the court has to properly consider the means and needs of the mother, the means and needs of the father, and the needs of the minor child, therefore make a maintenance award. There is a legal obligation upon the maintenance officer and the magistrate to conduct a thorough inquiry. The court should not play the role of an umpire. Therefore, a passive attitude should not be taken by a judicial officer in a maintenance inquiry, and then give judgment. Should all go well, at the end of the inquiry, a maintenance award should be made. We thank you for watching this video, and we would appreciate it if you could share this video, and we're looking forward to you partaking in the next live video. Thank you.